Kala documents incomplete. Tadi kalau time mati saya juga documents tulisan saya dia it will take some time. At least 2 years.
See, this is not super the person, they have no problem with the position of regularization of the person who originally given appointment appointment to license and then regularize again, and also given the permission to start. They cannot given retrospective seniority from the date of contractual appointment, but again, on the basis of regularization, it has a, there are two persons. Takan promotion gura laga hi dikin asa takan itu prahi confuse ko. But otherwise, there is regularization. Yes. So here, what has happened is the department did not sit for DPC for more than 10 years. Okay, so department after more than 10 years, department DPC set and their seniority was fixed from the date of their regularization in the from the date of their there are only Boy, tindahan charta inga sir. Mail or not passing the judgment.
Your worship also has no person. Everything will be extension of times
No, everything is under preparation. But all of time, within this, you have to go by the course. Actually, 3 years I said. I know someone kind of the other day I see that we will not dispose it of now. That's rule number 26. Government member commissioner appointment there from the date of expiry to Kitia 2019 yeah, it would be 2019 day. Head of the department maybe 20 years, 30 years back, and they are applying in 2022-23. Commissioner appointment is only within 3 years. Yeah, it will have corruption investigation. Judge of its own cause. Already given into the Gauhati no, we got right. And this permission to Wow, you are going to live long. You are going to live long, but I'm going to scold you now. You saw that everything to dispose of, making it up. I'm disposing of all my liabilities. Funny enough, when it is like, I should go to yeah. So, so, doing concept of interest. The other one I should not much now because I limited work because I have balcony and wedding money. अपने घर तो मशीन है तो ना मत ऐसे ना इसे ये बात पानी की बने पानी ऐसे ना लो पानी दूसरे को नहीं होता तो दूसरे को बनाए ना तो मैं बना मुझे करके बना बोला ini kan agak jenuh, online
May please, Lordship, I beg to mention item number 5.
Yes.
Lordship, I may be given some time to file my counter, Your Lordship. Here, the state as well as the private respondent, they have filed an SLP before the Supreme Court. So, Your Lordship, can you grant me some time, Your Lordship?
Lordship, here I just want to make one submission, Lordship. In the Supreme Court, interim was
If you
not,
want to make submission, then we'll take up by its turn. If you want to make submissions, then we'll take up as and when the matter is called up.
okay, Lordship.
May I please, the Lordship? Lordship, I beg to mention item number 4 and 5, Lordship. Item number 4. Item number 4.
4, yes.
Lordship, here, the state is yet to receive instruction, Lordship. So, Lordship, may I please to grant 3 weeks time, Lordship.
Okay, who is for the petitioner?
Your Lordship,
MS,
I'm for the appellant representing Gauhati.
Miss MS,
This is Nakiso. Lordship, we have no objection. However,
your name, please.
this is Nakiso.
Okay, learned counsel for the learned counsel. Representing Mr.
Gauhati,
Gauhati,
CGC.
learned counsel for the petitioner is present. Mr. N. Angami,
Vijumomi,
B. Jumomi, learned.
PP.
PP, public prosecutor.
Lordship, there is an interim. Let that
Ah.
continue.
Has sought listing of the case after
3 weeks.
2 weeks in order to obtain instructions in the matter. Post of the prior is allowed, list the case after 2 weeks. 182 weeks by the office. The interim order past earlier shall continue till the next date of listing.
Hello, Blacks.
May I please, Lordship? Lordship, I beg to mention item number 3, Lordship, on behalf of the council for the petitioner.
Okay, next.
Lordship, here we are yet to file our reply to the counter affidavit filed by the respondent number 2. So if Lordship, may kindly allow us 2 weeks time, Lordship.
You want to file reply affidavit?
Yes, Lordship.
Mr.
M. Vero.
M. Hero, learned counsel for the petitioner. Hers has prayed for and is granted How much time?
2 weeks time, Your Lordship.
2 weeks time
Yes,
to file affidavit in reply
yes, Your Lordship.
to the affidavit in opposition filed by the
Respondent number 2,
respondent number 2.
Your Lordship.
Anybody present, Mr.
Lordship.
So and so Jimomi, learned public prosecutor for the respondent number for the state of Nagaland. Public prosecutor Nagaland for the respondent number 1 is in attendance.
Lordship, there is an interim, if that may be
Interim.
continued.
The interim order passed earlier shall continue till the next
Obliged,
date
Your
of
Lordship.
listening.
May I please, my lord? Lordship, I beg to mention item number 8,
Yes,
on behalf of my colleague Livika, Your Lordship. She is indisposed today, Your Lordship. If 2 weeks' time can kindly be granted, my lord.
okay. You are for the PP?
Yes, yes.
Okay. Anybody
Mentioning on behalf of PP, Your Lordship.
mention on behalf of PP?
Yes,
public
yes,
prosecutor?
yes, Livika.
Okay, anybody from the petitioner side? There is no representation on behalf of the petitioner today on call. First of Mr.
And Angami, my lord.
N. Angami. You are also public prosecutor.
No, Your Lordship.
Learned N. Angami, Mr. N. Angami, learned counsel. Appearing on behalf of MS Livika, learned public prosecutor, Nagaland has submitted that MS Livika is indisposed and has paid for listing of the case after 2 weeks.
Lordship.
Okay. Okay, as prayed for, raise the case after 2 weeks.
Deeply obliged, my lord.
Lordship, we have complied with the order. of the court.
Yes, Lordship.
Heard Ms. Z. Chimoni, learned counsel for the petitioner, and Mr. N. Mojui, learned counsel for the
Respondent, Lordship.
respondent. Full stop. Okay, for the sole respondent, full stop. Mr. Mojui, learned counsel, has placed on record an order dated 26/4/2023.
Lordship.
Passed by the Principal Director, Directorate of Health and Family Welfare, Nagaland, whereby the petitioner has been appointed against a vacancy in the post of
LDA.
there is a post
LDA here is not.
LDA.
LDA.
stroke CA at chief or at the office of the chief medical officer,
Wow,
Mokokchang,
Lordship.
post of. It is his submission that the order in respect of which the instant contempt application has been filed
Lordship.
is already complied with. Post of MS Jimori, learned counsel for the petitioner, who has received a copy of the order, has endorsed the said submission of Mr. Mojui. Post of. As the order has been complied with, the instant contempt application is closed.
Lordship.
Lordship.
Lordship, let the order be placed on record, Lordship.
A copy of the order dated so and so is kept as part of the record.
Obliged, Lordship.
I don't think. Review revision takes.
With this lordship, this is a petition filed for quashing of the FIR dated 6 October 2017.
Where is the FIR?
Page 18 to 34.
Page 18.
18 to 34.
Okay. Where is the content? Where is the content? Gist.
Okay, page 17.
Okay, the case was registered
Registered on 6th of October.
6th of October. Okay. Who are the accused?
Lordship,
The
Yeah.
petitioners.
there are 11, petitioners.
Eleven
11
petitioners.
Yes, Lord.
All are accused.
Lordship, my
All are
humble-
accused.
yes, Lordship. Lordship, my humble prayer is that in the petition, we have inadvertently mentioned 3 accused name who has actually been discharged from the case. So if Lordship may also be kind enough to remove the names of the petitioner.
Who are
Petitioner number
they?
5,
Five.
petitioner number 5, petitioner number 7, and petitioner
Yan
number
Yan Potung.
Yan
Yan
Potang,
Potung.
Yan Potang.
Then
Petitioner number 7, Won Chitang Kikon.
Kikon.
Yes, Lordship.
Yes.
And petitioner number 8.
8.
Yes, Lordship.
Okay, after it was registered for offenses.
Lordship
IPC,
offenses
IPC.
under section 342.
Wrongful confinement.
Yes, Lordship. Section
Okay, wrongful
342.
confinement.
Yes, Lordship.
Cognizable, payable. Okay. Then 337.
352, Lordship.
Huh?
352.
No, 337.
Lordship, at the time of the, at the time of the
Okay,
CC.
one by one, 337.
Lordship,
Okay,
337.
Case was registered under what sections?
It was registered under
342, 337, 352, 363.
initially, Lordship.
That is what I'm asking you, case.
Yes, Lordship. 342,
Okay. 352.
363, 342, 337,
And 363.
363. Read with 75 JJ Act 2015.
Yes, CIBC. Okay, then after investigation, what happened? Charge sheet was submitted.
Yes, Lordship.
Where is the charge sheet?
Lordship, may kindly come to page 35, annexure F.
May it please your lordship. My lord, instead of going into the issues of the charge sheet, this issue is already compromised.
Right.
Yes, lordship.
Just because compromise is arrived at, all the cases cannot be quashed.
My lord, that is there.
That is a law. So that
Even
is
other-
why I am
yes.
trying to find out
My lord,
whether it is a case which can be quashed on the basis of compromise or not.
lordship. Perhaps my lord may appreciate the compromise agreement, the language is used there.
Okay, then what happened? What is the stage after charge sheet?
Lordship, examination of witnesses has begun and out of out of
Hmm.
11 witnesses. Witness number 1, witness 3, witness number 6 and 7, they have been examined. The rest are yet to be examined.
What is the nature of their evidence? What is the nature of their evidence? You had a copy?
Lordship, I do not have the copy.
Huh? Okay, who is for the informant?
My lord,
Yes.
for the private respondent number 2, I am the respondent.
Hmm.
I am the father of the child of
Yes. Yes.
the boy who had sustained injuries
Yes.
in this instance. And I had set the criminal law in motion by filing the FIR before the Woka police station, which had been registered as 29 of 17, my lord. Subsequently, after lodging the FIR, the parties have discussed and deliberated on the matter, and the informant, the victim, as well as the accused person, being from the same community, being from the same village in particular, we have decided to amicably resolve the matter, and therefore, my lord, I do not wish to pursue the matter any further.
Yes, PP. Anything?
No, lordship. Since the parties has decided to compromise, lordship.
Okay.
That has not much to say.
Yes, do you have
Yes, Lordship.
Decisions, Gyan Singh, Narinder, Lakshmi Narayan, Prabhat Bhai, what do you have?
Lordship, I may kindly come to 2011-10 SSC.
Decision name,
Lordship, in CG alias Babu and others versus Ratika and another. Lordship, may kindly come to para 13 and 17.
then next. Which decision?
Next, 2014, 5 SSC 688.
Narinder, Gyan Singh, Narinder, what? Which one?
Yogendra.
Narinder,
Yogendra.
huh? Yogendra.
Yes, Lord. Yogendra Yadav and others versus Serav Jarkhan and another. The relevant portion is a para 4.
Anything else?
Lordship may also come to 2019 5 SSC 688.
Name,
State of Madhya Pradesh versus Lakshmi Narayan and others.
okay. Hard, oh, sorry. The instant criminal petition under section 482, Code of Criminal Procedure 1973, within bracket that code and or the CRPC for short is preferred by 11 petitioners. Naam kita di dibo. Seeking quashing and setting aside of a first information report, FIR dated 6/10/2017, registered as Ukha Police Station, case number 29/2017. Within bracket, corresponding GR case number 47/2017, bracket close, on for offenses under sections 342 stroke this is wrong. Register for offenses why you have not changed this RC?
Lordship, I think I have made a mistake here where I think I have mentioned the sections which was
Wrong.
yes.
For offenses under sections 363, 342, 337, 352, Indian Penal Code, RW, section 75. Juvenile justice within bracket, care and protection of children, bracket close, Act, 2015. Full stop. And criminal proceedings arising out of the said affair. Full stop. Para. The petitioners were arraigned as accused by the investigating agency after institution of the FIR lodged by one Thung Bemo Nguli, who is impleaded as the respondent number 2 in the instant criminal petition. Full stop. In the FIR lodged on which date? 4/10/2017, the respondent number 2 as the informant had inter alia alleged that his minor son, aged about 15 years, was kidnapped at the instance of one ER, page 17 also, ER, E capital R, full stop, S full stop, Benrio, BENRIO, Kithan, KITHAN, along with his accomplices on 3/10/2017. Full stop. The informant, that's respondent number 2, had further alleged that his minor son was assaulted. As a result, he sustained serious injuries and he did not know whereabouts of his son. Full stop. Para. After registration of the FIR as a crime case, the petitioners herein were suspected to be involved in the crime alleged in the FIR. All were arrested or what?
Initially they were arrested.
And all of them were arrested by the investigating officer. Full stop. After carrying out investigation, the investigating officer on completion had submitted after registration of the case, the investigation was caused. Full stop. After completion of investigation in connection with Ukha Police Station case number 29/2017, the investigating officer had submitted a charge sheet under section 173 within bracket 2 CRPC by charge sheet number 74/2018 on 6/9/2018, finding a prima facie case for the offences under sections 342, 352, 325, 109, 34, 120B, IPC against eight number of accused And there, page 36. Okay. Benryok Ithan, who is the petitioner? Benryok Ithan is P1. Packet of petitioner number 1 likhe dibo. Kenneth Muri is 3,
Yes, Lordship.
P3. Terna Bemo Homestay, P6.
6.
Then Pong,
Michael. Number
Michael.
Petitioner number
Michael
2.
is 2,
2, Lordship.
P2. Orentum, P4. Then Manbemungli, P9. Then Yang Tongo Yum, P10. A Matung Tungo, 11. Then why these other petitioners? P11.
Worship,
Yantongo Ijum, Yantongo Ijum, Yantongo Ijum. Yes. Yes. Seven, 8, 6, Nguli. Nguli, P9. Yes. 6. I go in Nguli. Ah, 5, 7, and 8. They were not succeeded. Why you have?
Lordship,
Why they have
initially,
come?
initially, Lordship, when the names were submitted by the petitioners, all these 11 names were given to us, and on our part also, a little bit of a mistake on our part. I mean, like, we failed to check the chart sheet properly, and then that's how we made them a party.
What about P1, P2, Kalkirichu? Look at it. Hard, Mr.
Chingmai,
Mr.
Chingmai,
What is the spell?
CHINGMEI.
Okay. Chingmei Konyak,
Yes, Lordship.
Learned Council for the petitioners. Mr. PP and Angami. Pijimo, we learned Public prosecutor. Nagaland for the respondent number
One lordship.
one. Oh. One, and Mr.
Alezo, ALEZ.
Learned counsel for the respondent number two, that's the informant postal. Para. At the beginning, comma. Mr. Koniak, learned counsel for the petitioner has submitted that the petitioner number five, comma, the petition number seven and the petition number eight were not charge sheeted in the charge sheet. Number 74, 2018, dated 6/9/2018. Full stop. As those three petitioners were interrogated during the course of investigation, comma, the instant petition is also preferred by them along with the other petitioners, comma, who were charge sheeted, comma, inadvertently. Full stop. Mr. Koniak has submitted that in the proceedings subsequent to the stage of framing the charges, comma, these three petitioners are not accused in the trial. Full stop. Expressing apology, comma, Mr. Koniak has submitted that their name may be deleted as petitioners from the instant criminal petition. Full stop. They were not involved.
No lordship.
Para. Mr. Koniak, learned counsel for the petitioners, drawing attention to the charge sheet. Has submitted that after investigation, comma, the offenses under section 363 IPC and section 75, comma, Juvenile Justice so and so Act have been dropped, finding no materials in respect of those offenses. Full stop. It is further submitted by him that the offenses under section 342
Lordship, section 337.
342, huh?
337 has not been included. The three sections were removed.
Okay, 337. 363, 337, or 75. The offenses under section 342 IPC. Comma 352 IPC. And are compoundable in nature. Are compoundable in nature. Now are bailable and compoundable in nature. Full stop. Insofar as the offense under section 325 IPC is concerned, comma. Though the same is compoundable. The same is bailable and compoundable by the person to whom hurt is caused with a permission of the court. Full stop. The offense under section 109 is with regard to amendment. Full stop. It is his further submission that the trial has proceeded with the examination of prosecution witnesses. And as on date, comma, few of the prosecution witnesses are yet to be examined. Full stop.
Lordship,
In the court,
four witnesses has been examined. The remaining 7.
Okay. In the meantime, comma, the family members in the meantime, comma, the informant in the meantime, and the two sides, comma, that is, comma, the informant and that's respond number 2 side and the accused person side had discussed the matter about the unfortunate incident which happened on 3/10/2017. As both the sites belong to the same village and are also related. Full stop. The parties, after thorough deliberation, came to a general consensus that for peaceful and cordial future relationship, comma, it would be best for him to give a quietus to the dispute by burying the hatchet. Full stop. Considering an amicable settlement would be best for the parties to live in peace. The parties have decided to amicably settle the matter, and to that effect, comma, a compromise agreement was executed between the parties on 26/10/2022. Full stop. Para. It is in the aforesaid backdrop of events, comma, the instant criminal petition with the aforementioned prayers has been instituted. Full stop. Mr. So-and-so, learned counsel representing the respondent number 2 dash informant has endorsed the submission of Mr. Koniak, learned counsel for the petitioners, that the parties have amicably settled the matter and after thorough deliberation, comma, had entered into the compromise agreement on 26/10/2022, comma, a copy of which has been appended to the criminal petition as annexer
G. Lord. Page 6 is the last next.
Annexer G. Full stop. Where, Mr. Chuboni Lanet, public prosecutor, Nagaland, for the respondent number 1, has referred to the provisions of Section 320 CRPC and Section 482 CRPC. And has submitted that considering the nature of the offenses alleged, nature of the offenses in respect of which the charge sheet has been submitted and power available under the inherent power available under Section 482 CRPC and the precedents and authorities comma and the authorities in this regard, comma it would be in the interest of the parties that the dispute can be given a quietus since the parties have entered into a compromise agreement. Full stop. Para. The power under Section 482 of the CRPC code envisages 3 circumstances. Under which the inherent jurisdiction can be exercised, namely Roman 1 to give effect to an order under the code, semicolon, 2 to prevent abuse of the process of court, semicolon, and 3 to otherwise secure the ends of justice. To start. Inherent jurisdiction under the section, though wide, has to be exercised sparingly, carefully, and with necessary caution. In exercise of the power, the court would be justified to quash any proceeding only if it finds that initiation stroke continuance of it amounts to abuse of the process of court or quashing of these proceedings would otherwise serve the ends of justice. Full stop. It is right to say that the inherent power should not be exercised to stifle a legitimate prosecution. Full stop. Fair enough. Please take your seats. Whereas the scope of the inherent powers of the High Court available under Section 482 CRPC to quash criminal proceedings for offences which are non-compoundable in nature, but in respect of which the contesting parties have arrived at an amicable settlement, have been discussed elaborately in a number of decisions of the Supreme Court as well as of this court. Full stop. Para. In Yansing versus State of Punjab, reported in 2012, 10 SSC 303, the Honorable Supreme Court of India has observed and held as under para 61. Absolutely. After consideration, next para, after consideration of the decision in Yansing Supra, the Honorable Supreme Court in the case of Narinder Singh versus State of Punjab, reported in 2014 6 SSC 466, has observed in a similar manner, and the relevant parts of the state judgment are extracted here and there. 29. Parts of 29.1, 2, 3, 4, and up to 29.7. In Parbat Bhai Ahir versus Parbat alias Parbat Bhai Bhimsin Bhai Kamur and others versus State of Gujarat and another reported in 2017 9 SSC 641. A three-judge bench of the Honorable Supreme Court has summarized the broad principles as under paragraph 16. In the case of State of Madhya Pradesh versus Lakshminarayan, reported in 2019 5 SSC 688. comma, the Honorable Supreme Court of India has further observed as under paragraph 15. Where similar observations have been made in CG, Elias, Papu and others versus Radhika and another, reported in 2011, 10 SSC 705, and Yogendra Jadhav and others versus State of Jharkhand and another, comma, reported in 2014, 9 SSC 653. From the above conspectus of events as discussed here in above, comma, it has emerged that the parties herein have decided to settle the issues which arose between them and which led to the institution of the affair in respect of Ukha Police Station case number 29/2017 post-op. In view of the fact that the contesting parties have arrived at an amicable settlement by executing a compromise agreement on 26/10/2022. Comma, as in order to live in a peaceful manner in the future in the same village, comma, as alluded therein, comma, and in the light of the guidelines that can be culled out from the decisions of the Honorable Supreme Court as regards the power of this court available under section 482 CRPC, comma, this court is of the considered view that this is a case where the inherent power of the court available under section 482 CRPC can be exercised for the ends of justice. Full stop. It is reiterated that the contesting parties herein have settled their disputes amicably by entering into the compromise agreement dated 26/10/2022. Full stop. After it is submitted by the learned counsel for the petitioners, and the respondent number 2 does informant that after execution of the compromise agreement after execution of the compromise agreement on 26/10/2022 by way of amicable settlement, the parties have been living peacefully in coexistence in the same village. First off, and they and by putting their grievances against each other in the back burner. First off, instead of allowing the proceedings of GR case number 47/2017, arising out of Ukha Police Station case number 29/2017, which is presently pending in the court of pending before the Court of Learned Judicial Magistrate, first class, Ukha, to continue any further, where the inevitable conclusion in the backdrop of the above fact situation will be the acquittal of the petitioners charge-sheeted accused persons. At the end of the trial, the interest of justice will be best subserved if the charge sheet number /2018, arising out of Ukha police station case number so and so and ZR case number so and so. And the proceedings of ZR case number so and so pending against the petition number 1, petition number 2, petition number 3, petition number 5, petition number 6.
Lordship, petitioner number 4.
Huh?
Petitioner number 4.
Okay.
5
So
issues.
petition number 1, 2, 3, 4, 6, 9, 10, and 11. Right? 10 and 11 are quashed and set aside in order to enable the petitioners and respondent number 2, thus informant along with other members of their families and co-villagers to give a quietus to all the disputes and differences that arose between them earlier. Full stop. Accordingly, the charge sheet number so and so, dated so and so, arising out of Ukha police station case number so and the proceedings of GR case number so and so, arising therefrom and presently pending in the court of learned judicial magistrate first class Ukha, are quashed and set aside. To stop. Resultantly, all the consequential order passed in the proceeding in the course of the proceedings of GR case number so and so are also set aside. Full stop. With the observations made and direction given above, this criminal petition stands allowed to the extent indicated, no cost.
Obliged, Lordship.
Pleasure.
Item 5.
Same.
Our lordship here, I'm praying for 3 weeks time to file the
Again?
affidavit, yes.
Okay. Yes.
Lordship, stay was not granted in the Supreme Court. Now,
But if it is still in season of the proceeding,
Yes,
there are decisions that one should not pass subordinate, though it is not subordinate, but one should not pass any adverse order. There are decisions to that effect. Then otherwise, if I pass any effective order, then that will come, it will be adversely commented. Since they have issued notice perhaps,
yes,
notice is issued, Lordship.
yes.
Anyway, when stay is not granted, Lordship,
stay is not
in usual
granted.
course, the department, the government ought to abide by the learned single judge order that is in force.
What is
Because
your
when there is
single
no
judge
stay.
order? What is your learned single judge order? Do you have a copy of the order, Supreme Court order?
Lordship, I have
Lordship,
annexed.
I have here. On the last occasion also, lordship, I have produced before this court. I don't know whether it is inside.
Page 10, annexure A, Lordship.
Retrospective seniority.
Yes, lordship. So the state as well as the private respondent, they have preferred an appeal, yes.
After regularization, retrospective seniority.
No, Lordship,
Huh?
here, the question is, the department did not, DPC did not sit for more than a decade. In the meantime, all juniors superseded the petitioners. Juniors superseded the petitioner, they gave random promotion, Lordship. So when the petitioners were, DPC said after a decade, the DPC fixed their seniority from the date when their service was regularized in the lower grade. That is it. And in the Supreme Court also, they have admitted that here seniority was granted from the date, not from the date of regularization, but for only this department, they were upgraded. Seniority was counted from the date of upgradation. And from the date of upgradation means all juniors superseded the petitioners in upgradation. So nowhere in the department here in Nagaland, no.
Notice was issued under special repetition as well as under interim relief. So what happened thereafter?
Lordship, I don't have the latest court order, Lordship, so.
Because notice was also issued in
Yes.
case of interim relief.
Yes, and after that, some development also,
Oh.
the matter was collapsed, Your Lordship, so.
Better to have a particular instruction because notice is also on interim relief. If it is interim relief is granted, then our hands are tied.
Yes, Lordship, that if interim
Find out.
relief is granted, that is okay.
So,
But
I'll
it's not,
make it specific.
Lordship,
Hard MS J. Jimoni Learned Counsel for the petitioners and MS V. Sukri Learned Counsel for the,
for all the respondents,
for all the respondents.
1 and 2.
Full stop. Learned Counsel for the parties have submitted that against the judgment and order dated 9/9/2021, the state of Nagaland as well as the private respondents in a writ appeal
Yes,
WA 4/2020 have preferred SLPs. Full stop. In the SLP number 1136/2022, within bracket, the state of Nagaland and others versus M. Moa Nungba, MOA, NUN, ZBA and others, comma, the Honorable Supreme Court of India, while issuing notice on the SLP, comma, had also issued notice on the interim relief, making returnable in 6 weeks. Full stop. MS Sukri, Learned Counsel for the respondents, have sought for 2 weeks time,
Lordship, make
just
it,
a short time, Lordship,
4
to
or
give
3
clarification.
or 4 weeks, Lordship.
3 weeks time,
Okay, Lordship.
as regards the present status of the SLPs, as well as the prayer on interim relief.
Okay, Lordship.
Leaves the case after, the prayer is allowed, leaves the case after 3 weeks.
Okay. Much obliged.
Item 6, criminal petition unit 8.
May it please Lordship. Lordship, this is 482 application for quashing the FIR in charge sheet, my lord. My lord,
Lordship, I'm for the respondent number 2.
Your instruction? What is your instruction?
Lordship, I filed my affidavit.
Now tell me, if you have filed affidavit, what is your stand on?
Lordship,
submission?
since the matter has been amicably settled between the parties,
Okay.
I've been compensated for all the loss which I was made out. So Lordship, I have no objection in this regard.
Okay.
Lordship, the matter is about a financial transaction that has taken
Where is
place.
the FIR?
FIR is at page 9, my lord. Relevant portion starts from 11, my lord.
So case was charge-sheeted or?
Charge sheeted case, my lord.
Where is the affidavit? Now, what about this Borun Gandhi?
So far as that person is concerned, no adverse action has been initiated against him.
But he is not a petitioner here.
Yes, only I am for, only one is Chandraja.
Ah,
He's one of the directors of a company. And then only against him, and then he has been arrested.
he was arrested.
Yes, not in this case, my lord.
Ah. Before.
In another case, similarly of a financial transaction, he was arrested. And then in this matter also, the relating to different PS, different complainant. But then the court did not give the permission to be shown arrested, because before he was arrested, a compromise was already settled, since all the money has been returned to the complainant.
Now come to page 31.
My lord.
Last paragraph.
Yes, my lord.
Further, basing on the court order, I therefore return the case in final report to your honorable court. Purport of the case has been communicated to the complainant.
What happened, my lord, in this case?
Just before that, the paragraph.
Yes. He was arrested in another case, my lord. And then in this case, the investigation authority has asked the court to be shown arrested, but then the court declined that, because before that happened already.
Come, please read page 31.
Yes, my lord. Yes.
Last but one paragraph. Then on second
7-9,
paragraph, on
yes.
6-9, a written withdrawal of FIR copy. Okay. Then next paragraph, during case investigation. Okay. Then third, then on 7-9-2021, I have pray the shown arrest to honorable court with a prayer maybe of 7 days police remand, but was not granted by the honorable court, stating that the complaint in this instant case 3 Kivigo, Zimoni and accused party had submitted an MOU and they had no longer wished to proceed with the case, since it appears that matter pertains to a private dispute. Order sheet enclosed and annexed. Where is the order sheet?
That order sheet, right now I don't have with me.
The trial court might have closed it. Mr. Counsel?
Yes, so far that is, yes, my lord. But then,
See next time,
Yes.
further, based on the court order, based on the court
Yes.
order, I therefore return the case in final report, not charge-sheeted, to your honorable court. The purport of the case has been communicated to the complainant. So the trial court might have closed it.
no, my lord.
Where is the order then?
So far as the instruction is concerned, the case has not been closed.
No, it will be wrong on my part if the court has already closed it. Because what are the offenses, Mr. Counsel? See,
Yes, it's all compoundable, my lord.
all compoundable.
Yes, yes, my lord.
And
That is
MOU was submitted before the court.
Yes.
Okay. Oh, it is there. Where is the MOU?
Is it an exude? Page 21.
Okay, heard, Mr.
Vinogachumi, my.
Direct counsel for the petitioner. Mr. So-and-so, additional. Mr. Learned Public Prosecutor Nagaland for the respondent number 1, NMS.
Vikaliai. for respondent number 2.
Learned counsel for the respondent number 2 dash informant full stop. This criminal petition under section 482 CRBC. Code of Criminal Procedure 1973. Within bracket, the court and or the CRPC for short has been preferred seeking enforcement of the first information of a first information report registered as Dimapur Sub-Urban Police Station case number 59/2021. Within bracket. GR case number 457/2021. Semicolon the search sheet number 54/2021 submitted in connection with Dimapur Suburban Police Station case number 59/2021 semicolon and the criminal proceedings of GR case number 457/2021 presently pending before the court of learned chief judicial magistrate Dimapur, Nagaland. Full stop. Dimapur, Nagaland. Where the petitioner is facing the trial as an accused. Right?
Yes.
First. The facts leading to the filing of the instant criminal petition may be exposited as follows. The respondent number 2 as the informant. FIR, where is that FIR? Had filed a first information report, FIR before the officer in charge, Urban Police Station, Suburban Police Station, Dimapur Suburban Police Station. On 28/8/2021 against the present petitioner and another person named Mr. Varun, VARUN Kumar Gandhi as accused. Full stop. On receipt of the said FIR, the same was registered by General Diary entry number 06/2021. Subsequently, as Suburban Police Station case number 59/2021 for offences under sections 420, 407, 34, Indian Penal Code by the officer in charge, Suburban Police Station, Dimapur Suburban Police Station on 28/8/2021 and entrusted an assistant sub-inspector of police attached to the said police station to cause investigation. Post of subpara. In the FIR, the respondent number 2 herein as the informant has alleged that the said Mr. Varun Kumar Gandhi, representing himself as a director and authorized signatory of an incorporated company of a registered company, comma, Messrs. Lake House. Right, Lake,
Lake House in Private Limited.
where is that? Some document was there.
Yes, that is at an XJB.
Lake, L-A-K-E, space house, House, ST. Full stop, private limited. Comma, approached the informant and persuaded the informant to make investment in the said company, comma, which is claimed to be in the real estate stroke property development sector. Full stop. According to the informant, comma, on being so persuaded, comma, he decided to make investment in the said company, and to that effect, comma, an agreement dated 3/4/2021 was executed between Mr. Borun Kumar Gandhi as the authorized signatory of the company and the informant. Full stop. On execution of the agreement, comma, the informant handed over a sum of rupees 2.50 crore in cash to Mr. Borun Kumar Gandhi as the informant was given an assurance that the amount would be repaid within 3 months from the date of execution of the agreement. Full stop. The informant had alleged that he was given assurance that he would be repaid the principal sum and profits within 3 months. But when neither the principal amount nor the profit nor any profit was repaid within the stipulated period of 3 months, the informant tried to contact the accused persons, including the petitioner. Full stop. But none of them had responded to the call of the petitioner. Full stop. Which such grievance, the respondent number 2 as the informant had lodged the FIR in question. Full stop. Para, you were arrested in this case.
No, my lord.
On registration of the case, investigation was carried out. Full stop. The investigating officer of the case, after completion of investigation, in connection with Dimapur Suburban Police Station, case number 59/2021, submitted a charge sheet under submitted a final report form report under section 173 CRPC on 4/12 final report number 54/2021 on 4/12/2021. Full stop. In the final form stroke report, the IO had mentioned that on 6/9/2021, the informant, that's person number 2, had submitted in writing for withdrawal of the FIR, stating that the matter had been amicably settled between the parties. Full stop. He is not sure whether he is filing a charge or final form. IO is not sure whether he's, because there is he has not mentioned the name of the accused, see?
He has mentioned, my lord, page 31,
Huh?
that during case investigation, it was ascertained that the accused A1, it is mentioned there.
See, see the last line, further basing on the court order, I therefore return the case in final report to the honorable court. Final report. And next line, the purport of the case has been communicated to the complainant. So whenever a final report is submitted, notice is to be sent to the complainant. If it is charge sheet, notice is not required to be sent to the informant. So this is the problem. He is not, what he is writing, he doesn't know.
Yes.
So stop. Sapera. Nobody knows what. Where learned counsel for the petitioner has submitted that. In the meantime, a memorandum of understanding was entered into between the respondent number 2 dash informant and the present petitioner on 8/9/2021. After amicably settling all the disputes between them. Full stop. A copy of the said memorandum of understanding dated 8/9/2021 is annexed as Annex D to the instant criminal petition. Full stop. On perusal of the MOU dated 8/9/2021, comma, it is noticed that in the MOU, comma, it is mentioned that all the payments have been made to the informant, that's respondent number 2, and no financial liabilities of any nature is pending. Full stop. With the signing of the MOU, comma, all disputes, who are the financial liabilities have been amicably settled and there remains no further claim from the informant, that's respondent number 2. Full stop. Para. The MS so hey endorse the said submission আগৰ নিচিনাকে লিখি দিব আগৰ নিচিনাকে লিখি দিব public prosecutor same submission as like the other one then same decisions same revisions and pass last time to same just before that by order dated in 11/2022. This court, comma, in the interim, comma, state the further proceedings of GR case number 457/2021, comma, pending before the Court of Learned Chief Judicial Magistrate, Dimapur. Full stop. The case records of GR case number 457/2021 were also called for by the said order. Full stop. On perusal of the Case records of GR case number 457/2021, it is noticed that the criminal proceedings of GR case number 457/2021 has not attained finality despite submission of the final form stroke report by the IO of the case on 4/12/2021. Okay. Is yet to attain finality. Huh? Cost. Yes.
My lord, in this case also, same petitioner, different complainant, different case number. But in this case, it has not been charge sheeted, my lord. And in this case, he was arrested, my lord.
Okay, fast track it. Where is the file?
Page 11. ma'am.
It started 2 crores, 2 crore 50, 2 crore. Agreement dated 10/3/2021. Borun Gandhi same. East Dimapur East Police Station case. Number 148/2021 for the offenses under 406, 468, 420. FIR dated GD entry 05/2021 dated 23/7/2021. Case FIR registered date 9/8/2021. You are first respondent?
Yes, Your Honor.
Oh, same. It is different, right? No, they're like now, so you respond number same, no? Council same. So is MOU. The respondent number 2, this informant has submitted an affidavit in the instant case. Categorically stating that the dispute between the parties, all the disputes between the parties have been amicably settled by entering into a memorandum of settlement dated so and so. Here also affidavit.
Yes, ma'am.
Where is that? Same lake house. Agreement dated.
Same date, my lord.
Same
MOU
date.
also same.
Okay, same date. And MOU is also same date.
Same.
Yes. My other GR case number is 406/2021. Here the Sarsit clean alaga. Sarsit of Paku Nalaga. Just make a little the investigation of East Dimapur East or East Dimapur.
East PS.
Huh?
East police station only.
Okay. East Police Station, Dimapur. Case number 148/2021 is pending. As on date, resulting into a SARSI stroke final report.
I'll oblige, my lord.
May it please your lordship. Your lordship, this is a bill application under section 439, read with 37 of the NDBS Act, your lordship.
Yes. CD.
Your lordship, here the present alleged accused person was arrested on 1/2/2023, your lordship, on the basis of the statement made by one of the accused, one of the co-accused, who was arrested in connection to the FIR dated 24/01.
NDPS.
Yes, your lordship.
Oh, I'll be short of time. Let it be on Monday. I have to carry these orders.
Lordship.
37 is involved.
Lordship.
Section 37 NDPS is involved. Or what?
Lordship here.
Yes, your
Section
lordship.
37 is involved.
Yes, your lordship.
What is your name? Raju Rai.
Yes, your lordship.
What are the materials against him you just indicate?
Lordship. We'll do that on
Monday?
Lordship.
Mr. A. Lamkumar.
Tushidamjan.
Okay. Mr. Tosi Temjen Ponjenar,
Yes.
Learned Counsel for the petitioner is present. Mr. Jimoni, Learned Public Prosecutor has submitted that he has received the concerned case diary. And the case be posted on Monday in order to enable him to go through the same and to make submissions as regards the exact nature of involvement of the accused petitioner who are the offenses alleged against him. Release the case on Monday.
Lordship.
I think that criminal activity.
Yes. I've been told no CBI counsel has been engaged recently.
No, my lord.
Huh?
No, my lord.
Any Supreme Court?
No, my lord.
Then
Only High Court.
this will be persuasive, not an authority.
My lord, this,
I have not found any Supreme Court decision.
these of the cases, dismissal of acquittal or for non-prosecutions, this doesn't go up till the Supreme Court.
Huh?
This doesn't go up till the Supreme Court.
Has not gone to the Supreme Court. See, this is one enact,
Yes,
check bouncing,
yes.
right? Next one is mediation. Enact. Enact.
My lord, by placing these reliance, I just want to,
1 minute. This is not pure. This is not,
my lord, this
Yeah.
Jharkhand High Court Muhammad Kalamuddin versus the state of Jharkhand.
that is not sure what is the case about.
My lord, of course, but
If
here,
nothing is there.
here petition was dismissed for non-prosecution first.
We have to see, Mr. Council, here is a case which is under Prevention of Corruption Act. Prevention of
My-
Corruption Act is not similar to a case under check bounce, under section 138 Negotiable Instrument Act. These might be due to amicable settlement, the informant might not have pursued it, he decided not to appear. So it is automatically, say, dismissed.
That's why
For
my lord,
non-prosecution,
by
but here is a
placing-
case.
by placing this reliance, I just want to impress upon this court that appeal for acquittal against the acquittal order can also be dismissed for non-prosecution.
Right. On what parameters?
My lord. Or else, my lord, I have also submitted the list of dates for this case. They are not pursuing the case since 28/6/2022. 28/6.
No, I have been told because there is, because of some other official matter. I made an inquiry that there is no CBI counsel for last, say, 4-5 months.
Since July last year.
Not sure because of the view, Parshuram Patel versus State of Orissa. 1994, 4 SSC, para 9 of this AG. State of Orissa, 1994, 4 SSC. 664. Where it is said, it is now well settled that no criminal appeal can be dismissed on the ground of default in appearance. The court has to go through the record of the case, even in the absence of appellants or their counsel, and decide the matter on merit.
After that, coming to para 28. That is page 8. Para 28. This is relevant. I may be allowed to read out. The decision in Chandran's case, 1989, to Kerala such and such, did not also consider the scope of the inherent power of this court under section 482 of the court and power of this court to dismiss an appeal or any other criminal proceeding in exercise of that power or the power of restoration. Having considered those matters in details in the light of the pronouncement of the various high courts, I am of the considered view that this court has all the inherent powers to make any order to prevent the abuse of the process of court and for the ends of justice, and to enforce discipline by invoking the powers under section 482 of the code. Section 386 of the code, notwithstanding, the provision contained in section 386 cannot therefore have any application to the explosion of those inherent powers. Viewed from this angle, and in the light of the principle laid down in Ram Naresh Yadav case, 1987, such and such, I hold that this court has power to dismiss an appeal or any other criminal proceedings for default, and this court has also the power to restore such proceeding on sufficient ground being shown for non-appearance. But the right of dismissal and power of restoration can be exercised only by this court, and that too an exercise of the powers under section 482 of the code, and not of any other courts subordinate to this court, since those courts have no inherent power envisaged under section 482 of the code.
But you have to find an authority from Supreme Court. These are persuasive fellow, but not an authority. Not an authority.
I leave it to the court.
So it will be better, let us see. CBI must have been taking steps for engagement of a counsel. We'll see for that another 3 weeks. And in the meantime, you can find out an authority from the Supreme Court.
My lord.
Okay. Mr. Posego Patel, learning counsel for the respondent number 1, and Mr. Taka Kichel, learning counsel for the respondent number 2 are present.
My lord, for respondent number 3.
3.
My lord, 3
are present. None has appeared for the appellant today on call. The instant appeal has been preferred by the CBI as an appellant. It is submitted at the bar that it is found that on the previous 3 dates of listing of the appeal, that is, 14/3/2023, 17/4/2023, and 17/4 and 1/5/2023. None had appeared to pursue the appeal. Let the case come for ends of justice be listed after 3 weeks. We'll see, find out. Not authority from the Supreme Court.
Like, my lord.
Please return this.